Members, let's resume our meeting. Just now, members finished asking questions in the first round. The administration has replied to your questions in the first round. Depending on the progress of the meeting, if we progress well, we can make good use of our time to proceed with clause-by-clause scrutiny. Our meeting is scheduled to end at 6:30. Now let's get started with the second round. Mr. Lai Tong-kwok, 6 minutes questions and answers included. So please ask your questions in 3 minutes and allow the administration to get back to you. Thank you. I have 3 questions regarding the establishment. You suggest having 3 directorate positions. For these 3 positions, will they be civil servants within the government, or will you conduct open recruitment? If so, what requirements do you have? Especially when it comes to the position of the commissioner, he or she should have a wealth of experience or professional know-how. Apart from the 3 directorate positions, there will also be 8 permanent positions. What ranks are these positions? They come to a total of 11 staff members. Are they enough? I'm not talking about civilian staff members. These positions will have a lot on their plate. First of all, they will have to start on working on the COP. They will have to conduct meetings with others. You have 11 staff members. Are they sufficient? Is it sufficient? Regarding regulating authorities, there are 2 authorities. 1, the commissioner, and 2, designated authorities. There are 2. Between these 2 regulating authorities, in relation to enforcement actions, if they have conflicting views, from the legal point of view, if these 2 parties have conflicting views and cannot come to a conclusion or cannot come to a consensus, which one can make the final decision? This is my second question. My third question is that there are 2 designated authorities. Just now, a member also asked about this. There are a few large statutory organizations. They have similar functions as the designated authorities, say the Insurance Authority and the MPFA. There are a lot of companies or organizations under these authorities, especially the MPFA. They use a lot of computer systems. They are not included in this bill. What is the reason for this? The bill allows the Secretary to include more authorities, but do you have any plans? Any plans to review the list and to include more authorities to the list? You only have 11 staff members, and it's not enough. When you add more statutory organizations to the list of designated authorities, then you can ease the workload on the 11 staff members within the establishment. Thank you, Madam Chair. Thank you, Mr. Lai, for your questions. Regarding the establishment of the Commissioner's office, as mentioned in the paper, we will create 3 directorate positions. For the position of the Commissioner, Our plan is that the commissioner should have the related experience, professional know-how, and knowledge. Apart from this, the commissioner should also have a basic knowledge of the industry. That is to allow the commissioner to have enough capability to regulate the relevant organizations. So this will be conducted by way of open recruitment. From the perspective of network, experience, and know-how, we expect a capable individual to head the commissioner's office. The other two director positions will be assumed by officers under the Digital Policy Office and the Hong Kong Police Force respectively. The DPO will be responsible for technicality, whereas the police force will be responsible for reacting to incidents as well as incident investigation. Just now, Mr. Lai mentioned there will be a total of 11 staff members, and these are new additional staff members. But in fact, the DPO and the police force we arrange for officers to the commissioner's office. They will be seconded to the commissioner's office to render assistance. So in the entire establishment, there will be about 30 to 40 staff members, not just the 11 staff members which are new additional positions. In relation to any conflicting views between the commissioner's office and the designated authorities, which is actually unlikely in our opinion, but according to Section 54, if need be, the Commissioner may perform functions in respect of critical infrastructures and CI operators regulated by designated authorities if necessary. As I mentioned, if need be, or in accordance with Clause 54 of the bill, the Commissioner can or may perform function. The third question is, for instance, in relation to MPFA, we take into account some factors or criteria under the law. But whether regulating authorities are designated authorities, one of the factors is whether the regulated units are designated operators. Based on what we know, the MPFA covers the management of MPF as well as the taking out of insurance policies. In relation to the units under these authorities, they may not meet the criteria under the bill. Hong Kong people do not rely on these organizations. One of the factors in designated authorities is that an organization needs to meet the legal requirement of a designated operator. An operator may have something to do with the protection of computer systems, but it depends on the actual situation. So these are some factors in whether regulating authorities are designated authorities. There is no hard and fast rule in relation to review, but we keep a close watch on the situation as well as the developments in the industry. When the time is ripe, by way of subsidiary legislation, the Secretary for Security may appoint some authorities as designated authorities. Well, I have some follow-up. I hope the Bureau will consider this seriously. There were incidents in relation to MPFA upon the rollout of EMPF. MPF is a major protection offered to citizens in Hong Kong. I'm not talking about the platform per se. If there are incidents in relation to units in relation to MPFA, then there will be dire consequences or major consequences. The one who knows MPF the best is the MPFA instead of the commissioner. The authority will decide on who will be regulated under the bill. If you consider the time is not right now, no problem, but I hope that you will bear this in mind. However, many people you have say 30 to 40, but upon the passage of the legislation when it comes into operation, there will be some matters that crop up. If there's a lack of manpower and some staff members have to be seconded from other departments, then there will be problems. Ms. Elizabeth Quat. Thank you, Madam Chair. Upon the implementation of the bill, there will be difficulty. If there are guidelines, then they will be helpful to the implementation of the legislation. One on the definition of incidents, there could be manual error, technical restraints, terrorist acts, design fault, and so on. For standardized security incident investigation, say ISO or IEC 27043, we need to probe into the incident to make sure that the investigation is correct or the investigation findings are accurate. At present, there seems to be no requirement in relation to staff members of organization to undergo cybersecurity training. In our country or in the US, there are training requirements. The critical infrastructure operators will have to send staff members to undergo training in relation to cybersecurity. Different kinds of training have to be offered to staff members. In relation to third-party service providers, we understand cybersecurity services are outsourced to third-party service providers. When it comes to the definition of cybersecurity risks, we need to have a better definition. So if we can set out the definition of supply chains, and if we can pursue the legal obligation or liability of service providers, this will be helpful. My fourth point is the design of emergency response plan. Critical infrastructure operators are required to formulate an emergency response plan. But is there any standard? Say, we will draw reference from ISO 22301 in order to have a standard emergency response plan, or will you require that they conduct cybersecurity drill on a regular basis in order to respond to incidents in a timely manner. In case an incident happens, can they respond to such instantly? Will we draw reference from international standards? Thank you.
Deputy Secretary, Ms. Elizabeth Quad mentioned 4 questions about standard setting. Concerning classifying the incidents, we will make sure that we are making reference to the international standards mentioned by Ms. Quad in the COPs to be issued. Those standards mentioned by Ms. Quad will be our reference points. Concerning requirements on staff training, in the bill, there is a requirement under the Computer Security Management Plan in Schedule 3. A CIO must submit such a plan under the Category 2 obligations. One of these requirements is to provide training to a team of staff members under the operator to fulfill the requirements in the bill. Concerning third-party suppliers, we fully understand that if we can provide comparable international standards, it will facilitate the trade in complying with the requirements. So these will be included in the COPs in the future. We will not restrict, we will not impose restrictions on the operators in hiring third-party service providers. However, we will provide template contracts, including relevant conditions, to ensure that the supply will not be disrupted amidst geopolitical tensions. Concerning emergency plan, in Schedule 3, Section 2 of the bill, there are requirements about the emergency plan. In Schedule 6, there are also similar provisions detailed. Concerning the international standards to be referenced, we will provide a list of such international standards for the trade's reference. Chair, just now the Deputy Secretary said that there will definitely be requirements to train the operator staff members, but that is too loose. There must be a standard on what kind of training to be provided. That's why I said standards are so important. Staff must be subject to a certain hours of training. And about third-party service providers, is template contract sufficient to plug the loopholes? If the third-party service providers are not required to sign a compliance contract or compliance agreement, then that is not legally binding. We have to spell it out clearly in the bill to ensure that besides statutory requirements, there are standards for the trade to follow. I think the administration has heard the views. In Category 3 obligation, operators are required to draw up and implement security management plan. There are some standards to be fulfilled in the management plans, and also such conditions may be set out in the COPs. Next, Mr. Ambrose Lam. I would like to follow up on my third question about control of EVs. Now, in Part 3 of the bill, it specifies that the designated authority can designate the types of critical infrastructure and critical computer systems. Now, at present, EVs are not the mainstream on the road. However, if the computer system supporting these EVs are attacked and EVs are forced to a stop all of a sudden, imagine what will happen on the highways. And that may happen to EVs everywhere. So I strongly suggest the administration consider designating EVs as a type of critical infrastructure. Deputy Secretary. Thank you, Mr. Ambrose Lam. We will keep monitoring the developments of the technology. If the conditions for critical infrastructure operators are met in the bill, we will designate EV and the computer system as the critical infrastructure. Next, Ms. Doreen Kong. I would like to follow up on my question about audit. I've quoted the example of Singapore. One must register with the Singaporean government to become a registered auditor. Now, in the UK, there is the Cyber Resilience Audit Service Provider. There is a type of auditors to test the resilience of the cybernet. Now, since we have formulated this framework, can we get the most out of it? From what I heard, it seems that if the operator has an internal team of auditors, provided that there is sufficient firewall, then they can be the auditor. But will that be foolproof? Second, do we have the professional talents to carry out the resilience audit? Now, honestly speaking, if the operators are so capable in terms of cybersecurity, we don't need this bill. So do we have independent professionals capable to conduct independent audits for the operators? Now, just like Ms. Lai Tong Kwok mentioned, for MPFA and the Water Services Department, the DDPO has strengthened the supervision on these bodies so that they don't need to be regulated by the bill. But they have a heavy burden on them, emergency plans and also reporting in times of incidents. So do we have this requirement for the departments regulated by the DDPO? Finally, applications will have to be made to magistrates, including Section 31, applying for a court warrant. That's the simpler ones. And Section 37, the magistrate has the power to order acts to be done and so on. Now, these directions include monitoring, supervision, and maintaining the network. Now, I have high respect for the magistracy, but magistrates' courts are very busy. Do they have the time and effort and resources to deliver their duties under Section 37? Deputy Secretary, thank you. Concerning the auditing requirements in the bill, Now, besides Section 25, a requirement for the CIOs to conduct an audit, the bill also sets out the requirements for the professional qualification of auditors, or rather that would be set out in the COPs to be issued. Now, in the Council brief that we have prepared for the Bills Committee, in Annex D, there is an outline of the COPs concerning the vulnerability check and audit. We have set out the relevant professional qualifications for the auditors. These will be set out in the future COPs. We have also set out the scope of the COPs in the annex. There are also comparable international standards and also the contents of the audit report. Concerning the professional qualifications, we will keep up to date with the international standards. So we think it would be more flexible to designate the professional qualifications via the COPs rather than casting it in stone in the bill. So we will have professional qualifications requirements for auditors, just not in the bill. We will set out the comparable professional qualifications by way of the COPs. Say, for example, upon submission of the audit report, the designated authorities do not think the report is up to standard, then a written direction can be issued to the operators to conduct another audit. At present, the DDPO has a set of comprehensive guidelines and directives concerning the requirements for audits comparable to the bill. I will defer to the Assistant Commissioner of the Digital Policy Office for elaboration. On the third question, whether the magistracy has the time and resources to discharge their duties. Now, when the Commissioner's Office applies for a court warrant with the magistrate, sufficient information will be submitted to the court to ensure that the magistrates can render a fair and just decision on the application. Ms. Doreen Kong has pressed the button again, so I will give her a third round. Mr. Ben Chen. Chair, I have a clarification to make. Now, the bill will not apply to governmental departments. But what about subsidized organizations like the Science and Technology Park and also independent organizations fully subsidized by the government? Will they be regulated by the bill as well? And also the two examples of the designated authorities. They are licensing bodies responsible for regulating the licensees. Now, of course, the licensees would be heavily reliant upon these licensing bodies. However, for non-licensing bodies, which are designated authorities, will they have power over the operators? Can the government simply list all the licensing bodies as designated authorities, including the SFC? SFC is responsible for regulating the stock exchanges. Will the government include the SFC as a DA so that it can more effectively regulate the licensees. That may be a clearer approach. Now, the responsibilities are solely on the operators, but not the owners. Sometimes, the operators will operate the infrastructure in accordance with the conditions set out in the contracts drafted by the owner. Now, the responsibility is on the operator. But on the other hand, the owner, as the employer of the operator, should bear part of the responsibility or obligation as well. They should be partly responsible for the smooth and secured operation of the critical infrastructure. So will the government hold the owner accountable? Deputy Secretary, first question, whether we will include organization receiving government subsidy in the scope. Now let me stress again, governmental departments will not be subject to the scope of the bill because the DDPO has already a set of comprehensive regulations on these bodies. Whether an organization receives government subvention or subsidies is not a consideration behind the bill. Even for organizations wholly owned by the government, an operator may be appointed by the government to run the infrastructure. So financial support and the source of financial resources is not a consideration. Whether an operator is designated as a critical infrastructure operator will be decided according to Section 12 of the bill and the factors therein. So regardless of the income source and financial position, whether the organization is wholly or partly owned by the government, even though they are not governmental departments or bureaus, these are not the factors deciding whether they would be designated as a CIO. The main consideration is the type of service they provide, and also how dependent are they upon the critical computer system, and also the level of control over the critical infrastructure.
Now you mentioned other licensing bodies such as the SFC. That's quite unique as far as its position is concerned. But let me say that when considering whether a regulator should be appointed or designated as a designated authority, we need to have regard to the existing regime. That is to say, how much of the regulatory framework refers to computer system security or the complexity of the matter. For example, some authorities may also oversee some aspects of computer security, but then the coverage may not be such that it meets the requirement as a designated authority, like the Hong Kong MA or the Communications Authority. At the same time, we also consider whether the criteria set out are met. So take SFC as an example, as mentioned by Mr. Chen. All listed companies are regulated by SFC, but not all listed entities are possible targets of regulation as CIOs. So at the moment, the SFC does regulate a lot of companies. We also need to have regard to how much this regulatory framework is related to computer system security. Anyway, we will closely monitor the situation and, if need be, consider designating the SFC as a designated authority. Now, in relation to whether we should regulate owners by contractual means, well, we believe that under this bill, the legislative requirements can be made out in a clear manner to regulate operators instead of compelling owners to draw up contractual terms to regulate the operators of critical infrastructure. So we find the current approach more appropriate. Mr. Shang Hailong, I declare that I am an advisor to an INT startup in Hong Kong. I have 3 questions. About providing financial support to alleviate the financial burden of SMEs. Now, the Secretary referred to the technology voucher scheme, but the scheme has come to an end. No more application will be accepted. I believe that there are no more than 100 such INT SMEs in Hong Kong, so I believe an exception can be provided. My next question relates to the appeal board. I believe that disputes are unavoidable. And according to the bill, an appeal panel comprising 15 members will be established. How do we ensure independence? Now, if these are cybersecurity professionals, then they are somewhat influential figures in society, and they may be somewhat included in the list of government service providers. The third point is this, about the Security Bureau Chief being empowered to add more sectors to the list. We have 8 sectors in the bill. Now, if more sectors are to be included, and I'm talking about in the near term, say in 5, 8, or 10 years, then I suppose it's more palatable to add entities or organizations in the 8 sectors instead of adding more sectors to be regulated. So can you explain this rationale? Yes. Thank you, Chair. Thank you, Mr. Chang, for the questions. About support, as mentioned, most of the regulatees are large organizations, large corporations, listed entities. So basically, what we have in mind are not SMEs. Now, I gave an example just now, and I just realized that the technology voucher scheme came to an end and ceased accepting applications in the end of December. But since SMEs are not targets of this regulation, which need financial assistance, I don't think it's a major point, because we are mostly going to regulate large organizations. In Schedule 7, we spell out the fact that the chief executive will be responsible for appointing members to the appeal panel, and that these members must not hold any public office. This can ensure impartiality in the appeal process. In the event of conflict of interest, we can introduce administrative requirements. And in fact, we do have a standing requirement for declaration of interest. The appeal board will also abide by the principle of declaring conflict of interest to ensure that there won't be conflict of interest. The appeal board will comprise at least 15 members, or appeal panel. At least 2 will come from the I&T sector, 2 will come from the legal profession, and also 2 other lay members. So basically, there will be members who are just the average Joe, not related to either the IT or the legal sectors. Now, if an appeal board is to be set up to handle a case, members of the board will be selected from the panel. There will be sufficient members for selection to ensure no conflict of interest. Right, third question, 8 sectors. That means as the Secretary for Security can add more sectors to the bill by way of subsidiary legislation other than the existing 8. We do not plan to add more sectors to the bill at the moment. This provision is put in place for us to closely monitor the situation and add sectors to the bill if need be. But at the moment, we do not plan to do this in the short term. Right, picking up on what the DS said, I go back to my first question. Now, in these 8 sectors, we mostly find large corporations and listed entities. So is it the case that no financial assistance will come from the government? Indeed. We don't intend to provide financial support. And we haven't heard this concern raised by stakeholders in these 8 sectors. Next, Mr. Ronald Chan. Right, I have 3 more questions, and that will be the end of all my questions relating to the policy. I see for category 1, it covers telecommunications and the broadcasting sector. The same sector is regulated, the telecommunications sector is regulated by the mainland law, but not the broadcasting sector. With the rapid development of the internet nowadays, I question whether the broadcasting sector still has a significant influence. So, can you share with us why broadcasting sector has been added in the list of 8 sectors as well? And because this is a difference between your bill and the law in Hong Kong. The other question in the mainland. The other question is this: the commissioner will be appointed. He will lead a team of tech professionals, and at least this commissioner should have cross-disciplinary knowledge in the 8 sectors. This commissioner should be familiar with exactly what the computer systems are about and the operations of the 8 sectors. I don't think this is happening yet, but you will be submitting a proposal to create a post. This proposal will go through the establishment subcommittee and then the finance committee. But at this point, can you share with us what is the rank of this official? Because the commissioner will be communicating with the Hong Kong Monetary Authority and the Communications Authority. So can you tell us about this directorate post? What will it be pitched at? And the next question is this. more critical infrastructures can be added to your list by subsidiary legislation. Now, very soon we are going to examine the bill relating to stablecoin. In the future, a stablecoin issuer may establish presence in Hong Kong to the extent that it may be on a par with a major bank. So it may be designated as an operator of critical infrastructure as well. But before that, you need to talk to the stakeholders. I want to know, before designating any operator, will there be time for the commissioner to talk to the targets? Will there be sufficient time for them to get ready in order to comply with the legal requirements, such as having an office or address in Hong Kong and appointing a staff to oversee everything? So, what's the time frame from including an organization to the possible list of operators to the time of actually making the designation? Thank you for the question, Mr. Chan. Now, one of the 8 sectors mentioned is telecommunications and broadcasting sector. We note that there are similar requirements in the laws of other jurisdictions. Now, in the context of Hong Kong, you raised a point, and that is, in this internet age, broadcasting license holders may not be as significant as before. Still, we consider that for television and radio broadcasters, they still have a presence. They serve people of different age groups, in particular elderly people. There are people who don't use computers all the time. We have office workers only having access to radios, or some people may only have TVs at home. So these broadcasters provide an important source of information. So they're considered critical infrastructures. As such, we believe that the telecommunications and broadcasting sector should be included in our list. The Communications Authority also oversees other licensees, such as mobile network service providers, internet service providers. So in the local context, we believe that the broadcasting licensees still meet the requirements in the Cat 1 obligations. Now I refer to Clause 21, and of course we will have regard to the circumstances of individual operators when designating CIOs. About the commissioner, of course we're going to start an open recruitment exercise for the candidate of right caliber, with suitable qualification requirements and experience. And we propose to pitch it at the D3 or D4 level. Your next question is whether more CIOs will be added to the list. Now we will have regard to the issue you raised, such as a stablecoin issuer. Whether or not an operator should be subject to the regulation of this bill, we will follow the relevant codes of practice. The Hong Kong MA is one of the designated authorities the Hong Kong MA oversees the operation of stablecoins, so of course the Hong Kong MA will have regard to the issue. Second round, my turn. DS. I think by this time you should have a very good idea about the concerns of members, and that's critical infrastructures, the operators, and critical computer systems, and the relevant considerations when designating these things. Now, you mentioned the 8 sectors and that the bill does not apply to the government. Now, as mentioned by members, there are organizations wholly owned by or subsidized by the government. There are also statutory organizations such as the MPF Authority. It's a statutory body. But DS already explained that whether or not it should be reined in under the regulation, you don't consider the status, whether it's a statutory body or not. But still, when we come to the clause-by-clause examination, you should be fully prepared for some more questions from members. I think the energy sector is quite clear. For the I&T sector, for example, I think that there are other concerns. For example, about the AI supercomputing center. Well, this is something of a larger scale, but what about data centers or other computer centers? So for the AI supercomputing center, for example, there is one operated by the Cyberport. So do they fall under the bill? And also in the financial services sector, we have the CMU, the Central Money Maker Unit, and also RTGS, Real-Time Gross Settlement System. These are essential computer systems. We also have the Interbank Settlement Corporation, so as I said, CMU, RTGS. These are essential computer systems or critical computer systems. So taking the bottom-up approach, we look at the computer system. If the system is a critical computer system, then definitely the operator of the computer system would be a CIO. Now, if these are somewhat related to the Hong Kong MA or other regulators, such as the MPFA, then how are you going to answer these questions? I'm just throwing out these ideas for you to think about. For example, for the insurance authority, it regulates insurers. Not everybody takes out insurance policies, but banking services are quite essential to everybody. So perhaps when you prepare your written reply, you can think about all the factors mentioned in relation to the 8 sectors and tell us about your views. Just prepare your answers, because I think at the clause-by-clause stage, some more members will be putting more questions to you, specifically about whether the systems are critical computer systems. My next question is this. Now, a lot of details will be provided by the codes of practice. But time-wise, it will take time for the COPs to be drawn up after passage of the bill. So can you tell us more about the arrangement? Because the COPs are not part of your legislation. I just want to hear from you whether you'll be preparing the COPs even before the bill takes effect. Can you tell us, before the bill takes effect, whether you'll be drafting COPs to get everything ready? Like Ms. Elizabeth Quad said, whether the standards will be included in the COPs, and whether the relationship between the owners, operators, or third-party service providers will be made out more clearly. For example, whether templates of contracts can be provided through the COPs so that we find a clearer relationship among the three parties. I mean, the bill itself does not regulate owners, but still, I think you should spell these matters out.
DS, 1 minute for your reply. Thank you, Madam Chair. This is indeed a very good suggestion. In clause-by-clause scrutiny, especially when it comes to Clause 11, Clause 12, and Clause 13, that is the designation of critical infrastructures operators as well as critical computer systems. We expect to provide examples to members. To give you more information in this area, we'll let you know the criteria and factors and give you real examples. This is indeed a very good suggestion. Members put forward some suggestions and we'll consider them after the meeting. For questions put by Madam Chair, we hope to answer your questions at the next meeting. In relation to time, we're working round the clock to have work meetings with the industry. The bill is being scrutinized at present, but we don't stop the work in other areas. We'll conduct all the work in parallel. So we will announce a code of practice when the legislation comes into operation. In relation to preparatory work, the DPO, the police, as well as the Security Bureau are also working very hard. We have consulted the trade, and the trade was given opportunities to express their views. We want the COP to be practical, so we'll seize upon this chance. Upon the setup of the Commissioner's office, we want to be able to deal with this within this legislative year. So when this piece of legislation comes into operation, the COP announced at that juncture will cover the authorities that we want to cover. Thank you, Madam Chair. Thank you, DS. 2 members indicated that they would like to speak in the third round. Any other members? I'd like to manage the time well. If no, we'll allow these 2 members to ask in the third round. 6 minutes, questions and answers included, Ms. Doreen Kong. Thank you, Madam Chair, for giving us sufficient time. In case of an incident, will the authority issue a warning online? There's some information in this area. However, there is such a requirement in mainland China law. If one purchases computer system services from a third party, one needs to make sure that one is purchasing reliable services. One needs to sign an agreement with the service providers. All these are laid down in mainland China law. However, in our legislation, as the DS explained, we'll have to rely on the Code of Practice, COP. I'd like to know why. Many operators rely on third parties to provide computer system services. In relation to penalties, it's $300,000, $3 million, or $500,000, or $5 million. Say in clause 21, the penalty is $300,000 or $500,000. And for the other offense, the penalty is still $300,000 to $500,000. For the national law, you need to sign a warning first. If critical information infrastructures are involved, the penalty ranges between $100,000 and $1 million. Our penalty is quite severe, between $3 million and $5 million. Will the fine levels scare away operators? We do need operators to operate critical infrastructures. Regarding this critical infrastructure law, this is very important. Just now, Mr. Lai made a good point. When will you review this piece of legislation in Singapore? They said that they would review the piece of legislation every 5 years. Critical infrastructures evolve over time. When it comes to this bill, it's about computer systems. They may evolve within 3 years. So when will the administration review this piece of legislation? DS. Thank you, Mr. Wen Kong, for your questions. Regarding your first question, there is no requirement under this bill to make it mandatory for the Commissioner's office to announce any incident identified. However, if the Commissioner's office is of the opinion that it needs to contain the spread of the incident or to prevent the incident from affecting other sectors, which is actually within the purview of the Commissioner's office, if the office needs to prevent the spread of the incident from one sector to another sector, this is still within the purview of the office. Then, in this case, the Commissioner's office can remind other critical infrastructure operators. In the interest of the public, even if the incident does not require the Commissioner's office to make an announcement, in case of any disruption of service or attack, the public will be immediately affected. If need be, without disclosing trade secrets, we don't rule out the possibility that the Commissioner's office will make announcements in relation to the incident. As required by our country, agreements need to be signed by third parties. This is a national legal requirement. Among operators, they use different procurement models or different employment modes. With the code of practice, we'll have a better understanding of the situation in the trade or in the sector. Then we can announce standards that are better suited to the trade or industry, and we consider this practice suitable. In relation to maximum fines, it's $5 million. We have drawn reference from the Macau SAR arrangements. In Macau SAR, the maximum fines are equivalent to 4.9 million Hong Kong dollars. We have different amounts, say $3 million or $5 million. In simple terms, if the breaches are in relation to non-reporting of incidents without severely affecting the safety of computer systems. Say, if one fails to report any change in the address within 1 month without any imminent danger, the first fine will be $500,000. If there is a written direction that the operator will have to comply with the law, and any non-compliance would lead to a heftier fine of $5 million. For first-time offense, it will be lighter. However, for non-compliance with written directions, that means one fails to fulfill this statutory responsibility. And this offense will attract a heftier penalty. In relation to more substantial reporting of events, say failure to report any change in address will not give rise to dire consequence. However, if one fails to report any change in operatorship, the maximum fine will be $5 million. And these are our concerns, considerations, and reasons. Well, if I may have a quick follow-up, Madam Chair. I'll be quick. Just now the DS mentioned issuing internet warning to the public. Will the DS consider making it a duty of the Commissioner under Clause 4? We'll consider it. Thank you. And will you regularly review the situation? If we carve in stone in the legislation a time to review the legislation, it doesn't address the situation when technological advancements develop by leaps and bounds. If need be, we'll invoke subsidiary legislation to allow the Secretary for Security to make changes to the list. We'll closely monitor the situation, but we won't carve in stone a period of time when we conduct a review. So the DS means we'll conduct a review as appropriate from time to time instead of having a hard and fast requirement of 5 years. Next member, Ms. Elizabeth Quat. I'd like to ask about investigation and the collection of evidence. When it comes to cyber attacks and critical infrastructures, we do need to probe into the incident seriously. In the course of investigation, when it comes to the collection of evidence, we need to make sure evidence won't be tampered with in an illegal manner. This is essential. Under the bill, there are similar provisions. Is it in line with the evidence law in Hong Kong? Will we adopt ISO 27037, the international standard? We can guard against any unnecessary incidents which would undermine the value or effect of evidence. In relation to third-party service providers, are there any vetting mechanisms to ensure their capability or to ensure the fact that there is no conflict of interests? There are technical terms in the bill: dynamic data, static data, and another type of static data. There need to be clear guidelines. I'd like to point out the differences among these three sets of data. Static data means data stored in a database. Dynamic data means those that are in transition. The third type is less straightforward. It refers to data on buffer. However, in the course of forensic examination, it is this type of data that is the most useful. In case an incident happens, someone pulls a plug to stop the power, or someone is very impatient and reboot the entire system. And this will lead to the disappearance of this type of transient static data. The process of evidence collection is critical. Did someone do anything that interrupts the entire system or cause the collapse of the system? So there need to be technical guideline. For example, ISO 27040 to target the storage of data. The aim is to prevent any person from pulling the plug or rebooting the entire system. Which would lead to disappearance of evidence. DS, Ms. Elizabeth Quad asked very professional questions. I will answer these questions from the perspective of policy. Afterwards, I will give the floor to the police and the DPO to give you more information. We'll give you more information in relation to measures that we'll implement to prevent the disappearance of evidence. When we appoint designated officers, in accordance with Clause 51 of the bill, generally speaking, we will appoint public officers, as well as those that are employed by the authority, or those in connection with the authority's performance of a function under this ordinance. So, generally speaking, we won't appoint a third party. But it is provided under the bill that unless with the consent of the Secretary for Security, any other person or class of persons. Just now, Ms. Elizabeth Quad asked a lot of questions about professional standards. Or how to make sure the relevant evidence won't disappear. Under the bill, Clause 37 provides that a magistrate may issue a warrant authorizing an authorized officer of the Commissioner and any other person whose assistance is necessary for the execution of the warrant, including the fact that one cannot use the system and one needs to preserve the state of the system, to monitor the system, and so on. These are in relation to requirements from the legal perspective or from the policy perspective in order to ensure the preservation of evidence. I'll give the floor to the DPO or the police to answer questions of Ms. Elizabeth Quad in relation to professional standards or in the course of investigation. Thank you.
The police force. Thank you, Ms. Quad, for your questions. Ms. Quad mentioned the ISO 23037 and 24045. The trades do rely on these ISO standards. However, for the police force, whenever there is an incident, we would follow the standards laid down by the legislation and the courts in evidence gathering. Now, we have our own set of response guidelines. In the future, in our exchange with the stakeholders, we will require the stakeholders to formulate their own response plan. So that would include the response plans mentioned by Ms. Quart, including immediate cessation of certain activities and so on. Now, static and dynamic evidence gathering are different professional disciplines. We have our own experts to collect evidence at the scene, so we are confident in discharging that duty. Chair, about the transient static data that I mentioned, if our law doesn't specify what standards the trade or the frontline officers have to follow, then I am worried that the officers at site will reboot the system immediately, and then all the transient data will be gone. So can the police force give us a reply on this? We thank Ms. Elizabeth Quart for a suggestion. This is very valuable. In the future, we will remind the stakeholders by way of the codes of practice. In responding to incidents, there are some international guidelines for them to, international standards for them to follow so as to facilitate evidence gathering by the law enforcement agencies. Does any other member wish to speak on the policy matters? I will still allow these questions during the clause-by-clause scrutiny stage. Now, I would like to seek members' views. Do we need to invite submissions from the public? One way to do this is to invite members of the public to attend a public hearing, or we can invite written submissions. During the PowerPoint presentation, the administration has reported the progress of its consultation work to the panel, to the Bills Committee. What are members' views? Mr. Lai Tong-kwok. Since the administration has just concluded a consultation, and also there are more briefing sessions to be held by the administration, I think an invitation to the public for written submissions would suffice. Do all members agree? If that's the case, I will ask the Secretariat to upload a notice on the LegCo's website. Members can also invite written submissions from members of the public and interested bodies. And also, we will notify the 18 district councils of the invitations. Now, let's set the deadline on the 21st of January. That gives us 2 weeks. The written submissions received will be forwarded to Bills Committee's members as well as the administration for a consolidated reply. If there are no other questions, let's move on to the next item. Any other business? I would like to set a timetable for the next meeting. We can begin clause-by-clause scrutiny in the next meeting. We only have 15 minutes left, so I will not begin the clause-by-clause today. The next meeting will be held on Monday, 13th of January, 2:30 to 6:30 p.m. We will proceed quickly because all members think this bill to be very important. We need to complete the scrutiny process swiftly. So the next meeting is on the 13th of January, Monday, 2:30 to 6:30 p.m. I know members have a very busy schedule, so please be reminded that there are going to be 3 more meetings. The next one is the 13th of January. The next one is the 24th of January, Friday, 9 to 1. And then the 6th of February, Thursday, 9 to 1. And the last one is the 14th of February, Friday, 9 to 1. All meetings will last 4 hours with a break in between. I thank the administration for accommodating our schedule. Any AOB? Now the meeting is adjourned. Thank you.